As many of us are starting to get used to some parts of the new normal by working from home, it can present some challenges, well, a lot of challenges actually. And Adams & Adams, a firm that specializes in intellectual property, have raised some questions in this regard. They ask, what legal effect does remote working have on intellectual property rights in the workplace? Well, joining us now to discuss this is trademark lawyer Darren Olivier, who is from Adams & Adams. Darren, great to have you again. Welcome to Morning Live.
Hi, Leanne. Lovely to be on the show.
Yeah. So, in a nutshell, why has your company raised this issue specifically?
Well, I think you just have a look at, right, let's just say innovation in society today, disruption and this new normal that you referred to earlier is key to being sustainable, embracing the innovation, and there's been a lot of it over the last year or so. And then also from an employer's perspective is being able to preserve it, control it, and protect it. And if you look at it like that and say, okay, therefore innovation is important within the organization, therefore at least having a knowledge of how it is protected and preserved and controlled is important. And then it reflects on what we call intellectual property laws, and that's where we get involved. And these intellectual property laws, there are 5 of them. I'll just quickly run through. It's patents, trademarks, copyright designs, and kind of trade secrets or know-how. And each of them have their own little laws or little rules on who owns it, who is the owner, whether it be a trademark or a patent. They've got their little rules. And then it's linked to employment. And of course, employment is linked to a workplace. And if you change the workplace through remote working, it affects these laws. And so the questions that we are raising is, are you aware of how these laws operate and what the effect of a remote working environment might be on the intellectual property and therefore the innovation and your ability as an employer to preserve control and actually nurture it? And that's where we've come in.
So what is the difference really? I mean, perhaps you can explain to us. Surely there must be some of the same concerns about intellectual property rights if you're working from an office. Why online at home as opposed to in the office?
Yeah, so, I mean, let's just take a simple example. And if you actually got, in the past, let's call it a traditional workplace, you got this McCarthy versus Vodacom decision, that whole thing that's still brewing in the background. But a lot of it has to be, and at very basic level, without getting into too much detail, if things are developed in the course and scope of your employment, then traditionally it's owned by the employer, subject to certain exceptions, and there are, and I won't go into them right now. But let's just have a look at this course and scope of employment. Now, let's assume I'm at home now, and I'm working, but things have changed. This 8-hour day that we're so accustomed to has changed. It's now almost kind of merged and fluid within your own life at home. And so there's a distinction between what is actually done while you're doing work for a firm or your business, and what is done through your own intellect and through your own thought processes, which is actually your domain, your innovation. So it becomes difficult to discern what is during the course and scope of employment and what is not during the course of the scope of employment. And that's where the boundary becomes very blurred.
Okay. So you say that many businesses may actually need to rethink their agreements and policies in this new space to actually mitigate a potential loss of the intellectual property rights. So this is kind of a thing where companies really need to take this very, very seriously. What do you recommend they actually do at this point in time?
Yes, no, I think so. Yes, that's one example, Lee. I mean, there are others. I mean, just to go into it and then answer your question, if I may.
Sure.
So, say for example, with this remote working, also going to get what's going to arise is a rise in subcontracting. So less employees perhaps, and a rise in using subcontracting, because it just gives so much flexibility to both employer and employee. So in a subcontracting environment where they're not doing work in the course and scope of employment, then of course the creator in many instances will be the owner of the copyright. So you can outsource the design of your logo or your computer program, and in many cases that developer or that design is going to own the rights into that innovation. So to answer to your second point, the course and scope of employment and these subcontracting contracts need to be looked at. So what does that mean? It means going through and literally auditing what your employment contract looks like, getting in touch with an employment lawyer and asking him or her to have a look at these clauses to see if they are protecting you. And also, not so much, it's important to protect it from an employer's point of view, but also it's important to nurture it and incentivize it from an employee's point of view. They're both for both, right? So you want your employee who may be outside the organization, may not be part of these team cuddles and these innovation think tanks all the time, and a lot of innovation happens in the workplace. How are you going to get that employee to be incentivized to come up with these bright ideas that you need to become sustainable? And that's where looking at policies, looking at agreements is so important.
Now, you've also said in this remote working environment, one should actually appreciate that accurately determining which aspects of creativity or innovation are within the course and scope of an employment contract and which are actually not, become considerably more challenging and open to abuse. So when is work-related creativity not the right of the employer, and how can they be open to abuse?
Well, you can imagine, let's say, I mean, it happens often in the software development space. Or you sitting in, let's say, a financial organization which has been disrupted enormously by technology. And, you know, you're there and you've come up with this bright idea. Or is it culture, you know, is it nurtured by the organization? Is it the organization that's allowed you to come up with this idea, or have you just come up with this idea independently? And then it's a question of who owns the idea, right? So the idea, a lot of intellectual property laws don't allow you to own the idea. It's actually the manifestation of that idea on whatever it be, paper or in a computer program, and that's what gets protected, apart from, you know, a patent. But defining that can be very tricky. I mean, it's very easy in an organization. You can say, okay, we were in that meeting and this is what we came up in the meeting, and there are minutes or there's a recordation of that meeting, and therefore, you know, I can rightfully lay claim to that. Whereas this innovation that takes place independently of that, and it can happen quite easily, you know, even around a braai with mates, or around a dinner table talking with friends, you know, you can come up with ideas and etc. So I think from both aspects, from an employee aspect, if you come up with an idea and you want to make sure that actually, really, this is my idea, it's not a bad idea to document it, and not a bad idea to just put on paper or whatever, just jot down why, you know, not why you think it's your idea, but when you created it, and really to show that you didn't create it during work hours, and vice versa for the employer. So I think that becomes very important. Communication becomes very important, and of course both can be manipulated. So one has to be quite careful. And I think, yeah, it's just a bit of practical common sense, but also contractual terms I think are important to get this right.
Yeah. All right. So let's look at a recent survey that was actually done, which is quite interesting. You say 88% of the respondents prefer to either work from home or a combination of both, home and office. But despite this, 67% of those actually surveyed have not altered their work policies or agreements for remote working. And those that did, only 7% made any change to their intellectual property management regime. It is with this that you highlight intellectual property that becomes considerably more challenging and open to abuse, no doubt, in remote working. Let's address a couple of them individually, starting with the copyrights that you mentioned earlier, and then perhaps patents and designs.
Yes. Right, so that survey is interesting. So, I mean, that survey endorses what we're talking about. Really, there's going to be a remote working revolution. That's happening as we speak. So there, you take that, then you have a look and you say only 7% are looking at IP clauses. That's quite low. It's not surprising, to be honest with you. I mean, a lot of organizations, I don't think, pay enough attention to IP laws and innovation. Of course, I would say that, but I think it's a fact. And then, if you look at these individuals, so I mentioned 5 of them before. Copyright works on a basis that the creator, in most senses, will be the owner. So if you imagine that your creator is either outside your course and scope of employment or subcontracted, you need to deal with that. Okay, so that IP is assigned to the organization if that is the case, right? Or at least negotiated. When it comes to computer programs, which is vastly protected by copyright in South Africa, then it's the person who exercises the control over the making of that. So that's the wording of the legislature. So then you've got to say, who is exercising the control over the making of it? If it's not underemployment, so if it's subcontracted, which a lot of the software development code is, so then you've got to say, okay, in an organization, if they're in your traditional workplace, you can far more easily say, I am exercising control over the making of that computer program, therefore I own the IP rights. In a remote working environment, it becomes much more difficult to do that, and therefore increases the need for a contract to regulate that position. Otherwise, you're going to lose that innovation through that software. So that's copyright, really. Let's talk about trademarks. So trademarks is all about, who adopted the brand and who made the brand, who came up with the name of that brand. So it's slightly easier, the adoption. Of course, the rights in the trademark will arise through use of that trademark as well as registration. So it's really first to the register and first to develop a reputation in that brand. A little bit more easy to sort out, but we have seen instances, especially with startup companies, someone coming up and saying, listen, I'm registering this trademark in my own name, and then effectively licensing it to the startup, and then a lot of things happen in that relationship. So one has to also look at trademarks, how that works. Trade secrets are an interesting one. I mean, what you don't patent, what you don't reveal to the patent office as an invention, you can retain for almost, well, as long as you can keep it a secret, this type of form of protection. So if you're thinking of, like, let's say, the secret formula of Coke, to the extent that one can say that it exists, but certainly it's said to exist, the longer, the length they can keep that secret for forever, and then it will remain protectable in theory for forever. So the question is, okay, then how does this trade secret arise? How do I make sure that people are keeping it confidential? And this is often an issue, because remote working often means working from home. It often means working with a spouse or a partner, people in the house, and there is a practical challenge of keeping things confidential. Yeah. And as soon as it's not confidential, it fails to be a trade secret and then fails to be protectable. So one has to not only look at then the policies, but also how does one set up a remote working environment to ensure confidentiality can take place. And I'm sure you can appreciate that as soon as you take that into the demographics of South Africa, you get people with homes that are quite capable of doing that, and then other homes where really it is really communal living. So there is a challenge in and of itself. Okay.
Listen, we got to leave it there. I'm sure a lot of people appreciating some of the advice that you're giving here when it comes to this kind of environment, intellectual property rights. Thank you again for joining us, trademark lawyer Darren Olivier from Adams & Adams. And if that is an issue for you, I hope these answer just a couple of questions about intellectual property rights in this new normal work environment. All right, let's take a quick